A standard civil trial is a war of attrition. The process of discovery, pretrial conferencing, and witness examination drains time and capital for years. But litigators do not always have to endure the trial phase. It is possible to secure a final decision before a single piece of evidence is presented in court. The mechanism to achieve this is Rule 34, Judgment on the Pleadings. It operates as a procedural guillotine. A successful Rule 34 motion does not rely on the strength of the plaintiff's evidence. It relies entirely on isolating and exploiting fatal structural flaws in the defendant's own written answer. We are going to conduct a forensic audit of Rule 34. We will examine the core mechanics of Section 1 and the aggressive procedural traps introduced by the 2019 amendments in Section 2. By mapping these rules, we will isolate the exact edge cases and jurisdictional pitfalls that bar examiners consistently use to test a candidate's procedural competence. Understanding how to deploy this motion separates a litigator who slogs through unnecessary trials from one who secures an instant paper-based victory. Look at the text of Section 1 on screen. The court may direct a judgment on the pleadings when the answer fails to tender an issue or otherwise admits the material allegations. The underlying logic is simple. The entire purpose of a trial is to resolve disputed facts. If the defendant does not actually dispute the plaintiff's facts, a trial is a waste of judicial resources. The first trigger is an answer that fails to tender an issue. This occurs when the defendant submits a pleading that evades the core allegations, offering vague statements that do not amount to a specific legal denial. The second trigger is a direct admission. The defendant expressly agrees with the material allegations raised in the plaintiff's complaint. When evaluating this motion, the judge is restricted to the elements shown on this scale. They must look exclusively at the complaint and the answer. Notice the red barrier. The court is strictly forbidden from considering evidence aliende, any outside proof, or extraneous documents. The decision lives or dies on the pleadings alone. Because of this strict limitation, a motion for judgment on the pleadings is generally the exclusive tool of the claiming party, the plaintiff who spots the defensive weakness. A precise complaint met with a sloppy answer creates a closed universe of facts favoring the plaintiff, resulting in an inescapable legal checkmate. There is a major exception. As the text indicates, an admission does not grant an automatic victory in cases involving the annulment of marriage or legal separation. The state protects the institution of marriage. To prevent couples from colluding to dissolve their union by simply fabricating mutually agreeable pleadings, the law intervenes. Bar examiners consistently test this with a classic trap. A husband files for annulment, and the wife files an answer completely admitting to her own psychological incapacity. Even with that full admission on paper, the plaintiff's Rule 34 motion will be denied. Family law strictly requires actual proof and a trial on the merits to verify the facts. Outside of family law, defendants often trap themselves by utilizing a drafting error known as a negative pregnant. Watch this text breakdown. I did not borrow exactly $10,000 on Tuesday. By denying specific modifiers, they leave the core fact intact. Courts view a negative pregnant as a disguised admission. The defendant admitted they borrowed money, making their pleading a target. Form is just as fatal as substance. A defendant may subjectively intend to fight the case, but failing to execute a proper general denial triggers the procedural guillotine anyway. To stop litigators from using motions to stall cases, the 2019 amendments added Section 2. This section reconfigured the court's power dynamics. Judges no longer have to wait for a plaintiff to file a motion to end the case. Judges now possess the authority to render judgment on the pleadings motu proprio, on their own volition, if the answer's lack of an issue is apparent. Under Rule 18, judges will proactively include this mandate in the pretrial order, directing the case straight to judgment without memos or position papers. If the admission is not immediately obvious, the party's motion is simply routed through the standard procedures for litigious motions under Rule 15. This flowchart tracks the most aggressive update in the 2019 amendments. Any action of the court on a motion for judgment on the pleadings is now strictly immune from being questioned via an appeal, certiorari, prohibition, or mandamus. That prohibition applies to any action, whether the judge grants or denies the motion. The route to the appellate court is severed. A losing lawyer must proceed through the entire trial and raise the denial during the final appeal. Examiners bait this trap precisely. They construct a scenario where a judge outright denies a plaintiff's Rule 34 motion. The aggrieved plaintiff immediately files a petition for certiorari to the Court of Appeals, alleging grave abuse of discretion. Candidates fail this question by taking the bait. They waste paragraphs analyzing whether the judge's actions actually constituted grave abuse of discretion. The correct analysis ignores the judge's reasoning entirely. The petition fails at the procedural threshold because Section 2 expressly prohibits filing it in the first place. By locking down interlocutory appeals, the 2019 amendments eradicated Rule 34 as a tool for interlocutory delay, forcing litigators into a binary outcome: win cleanly on the pleadings or accept the reality of a full trial. The final requirement for mastery is distinguishing judgment on the pleadings from its closest procedural counterpart, summary judgment under Rule 35. We can map their exact differences using this side-by-side matrix. Look at the grounds. Rule 34 triggers when an answer admits facts or fails to tender an issue. Rule 35 triggers when there is no genuine issue as to any material fact. Their evidentiary basis separates them completely. As shown on the left, Rule 34 isolates the analysis exclusively to the paper pleadings. On the right, Rule 35 demands the opposite. It requires the introduction of evidence aliunde, affidavits, depositions, and admissions, to prove the facts are settled. Because Rule 34 attacks the answer, it is almost exclusively available to the claiming party. Summary judgment, however, can be leveraged by either the claiming party or the defending party. Their mechanical inputs are entirely different, but their function is the same: disposing of civil cases that do not require a full trial. Misidentifying the problem and selecting the wrong procedural tool leads directly to a dismissed motion. But litigators who memorize the strict parameters of Rule 34 and respect the 2019 appellate lockdown can execute a clean victory before the trial even begins.